Well, good evening, everyone. Welcome to this event in the CCCS Global Public Law Seminar Series, which tonight is hosted jointly with the Gilbert and Tobin Centre at the University of New South Wales. I'm Cheryl Saunders and I'll be chairing the seminar tonight. A particular welcome to our panellists, Justice Virgil Narakobi, Dr. Essa Apinelu, Professor Hugh Corder and Professor Ros Dixon. And an even more particular welcome to Dr. Anna Jedgetz, whose book is the focus of discussion for this event. And a welcome also to the distinguished audience online tonight, including judges from Pacific jurisdictions. We really very much appreciate you joining us here. Let me begin by acknowledging the Boon Wurrung people, the traditional custodians of the land from which I'm presently speaking. I also pay my respects to the elders, both past and present, of the Kulin Nation, and I extend that respect to other Indigenous Australians participating in this seminar today. Now, this seminar is the occasion for the celebration and launch of an important new book by Anna Jedgetz on the use of foreign judges in the 9 Pacific states that have a common law orientation. It's a handsome publication by Hart in its series on judging and the courts. See here, for those of you who haven't actually seen it, and hopefully you will soon. And many thanks to Anna for allowing us to launch the book in this way. Even more importantly, as with all the seminars in this series, the event tonight is intended to engage with the ideas in the book. They raise significant and highly topical issues in countries across the Pacific region and by extension elsewhere in the world. And they suggest the practice may be in flux for all kinds of reasons, which include the ongoing challenge of accommodating foreign judges within a framework of principle and practice developed with local judges in mind. Now, I don't want to preempt what our panelists are going to say, so just a few words to introduce the scope of the book for those who have not yet had the opportunity to see it. The book gives a detailed empirical account of the usage of foreign judges in the Pacific at the time it was written. In doing so, it necessarily engages with the definitional question of what makes a judge foreign for this purpose. It also considers the practicalities of recourse to foreign rather than local judges, including their implications for the regulatory framework to be applied. And it uses these realities as a foundation on which to examine a series of important questions of principle, the implications of the use of foreign judges for the nature of constitutional adjudication, for judicial independence, and for the representative quality of courts. And the book concludes with reflections on the use of foreign judges from a series of transnational perspectives, which also include the rationales for the practice. Now, I propose that we proceed this evening as follows. In a moment, I'll introduce each of our 4 panellists, who between them cover a very wide range of relevant perspectives on tonight's topic. Each of them will speak in the order in which they're introduced for 10 minutes or so. At the end of their presentations, I'll introduce Anna properly and invite her to respond or to say anything about the book that she wishes. And there should then be some time for further exchange between the panelists and the author, and hopefully, time permitting, for some questions from the audience using the Q&A function. And we'll wrap up promptly around about 7 p.m. Melbourne time. So let me begin by introducing all 4 panelists, and then we'll move to the presentations. Justice Virgil Narakobi is a judge of the National and Supreme Court of Papua New Guinea. He was previously legal counsel at the Ombudsman Commission of Papua New Guinea, and he's been president of the Papua New Guinea Law Society. He holds an LLB from the University of Papua New Guinea, an LLM from Cambridge, and a PhD from the Victoria University of Wellington, which was on the subject of the implementation of PNG's national goals and directive principles. Dr. Essa Apinelu is the Attorney General for Tuvalu. She was Tuvalu's first female lawyer, and she's been a valued participant in the Melbourne Forum. She holds a PhD from Swinburne University for a thesis entitled Standing Under Fenwa, Customary Rights and Human Rights in Post-Colonial Tuvalu. Our third panelist, Hugh Corder, held the chair of public law at the University of Cape Town from 1987 to 2019, and is now a senior research scholar in public law. He served as a technical advisor in the drafting of the Transitional Bill of Rights for South Africa in 1993, and he deserves credit for South Africa's constitutional right to administrative justice. He's taken a particular interest in judicial appointments and accountability mechanisms in South Africa and in Southern Africa more generally, and he'll speak from those perspectives tonight. And finally, but certainly not least, Ros Dixon is a professor of law and director of the Gilbert and Tobit Centre at the University of New South Wales, with which tonight's seminar is shared. She's the immediate past co-president of the International Society for Public Law. She's a well-known scholar of comparative constitutional law and has written on the use of foreign judges in hybrid courts in various parts of the world, casting the practice in yet another light. So what a wonderful array. I'm very much looking forward to hearing from each of our speakers. And Justice Narakobi, if we can begin with you, thank you.
Thank you, Cheryl. And again, my thanks to be invited to be part of this panel on this important subject. Let me begin by congratulating Anna for her accomplishments, her PhD, as well as being able to get her research published. I have about 10 minutes or so to present my, or to give my presentation. So I'll just, in the interest of time and to allow me to be able to say as much as I can, I will follow from the notes that I have prepared.
Sure.
All right. So the Pacific is one of the few regions of the world where foreign judges sit to hear constitutional issues. The research undertaken by Dr. Anna Dzejic in a PhD thesis, which is now published as Foreign Judges in the Pacific, seeks to understand the engagement of foreign judges in the Pacific and the social, cultural, legal implications it has had in our respective Pacific Island jurisdictions. The definition of a foreign judge the study adopts is straightforward. A foreign judge is a judge who is not a citizen on whose courts he or she serves. Foreign judges in the Pacific attempts to answer 4 questions. Does the nationality of the judge who decides constitutional issues matter? 2, do foreign judges bring a special degree of impartiality and independence to the task of judging? 3, does foreignness affect the judge's sense of responsibility and accountability to the state and the people? And 4, how can the conception of the judge and the judge's role accommodate the movement of judges across national borders? The judiciaries of 9 Pacific countries were studied in detail to answer these questions: Fiji, Kiribati, Nauru, PNG, Samoa, Solomon Islands, Tonga, Tuvalu, and Vanuatu. The study looks at the work of 225 African, Australian, British, New Zealand, Sri Lankan, and Pacific Island lawyers and judges who have served as foreign judges on Pacific courts in the past 2 decades. It is a detailed research given the number of countries it has studied, the interviews conducted, and the literature that have been carefully considered and analyzed to reach the conclusions and recommendations of the study. Given that Pacific laws and legal institutions does not feature much in comparative constitutional law studies, foreign judges in the Pacific is an important contributor in comparative constitutional law. Let me state early here that Pacific Island countries allow for foreign judges to serve in their jurisdiction. Papua New Guinea, the Constitutional Planning Committee report of 1974, which contained the recommendations and rationale for the country's constitution, provides for foreign judges, and it is also set out in the organic law on terms and conditions of judges, a constitutional law in PNG. From the analysis taken by the book, there were three incidents that stood out to me that lend support to the view that the nationality of judges who decides constitutional cases matter. And these were the cases which came about from the 2006 coup in Fiji, the Tionea and Pule o Kaupule of Nanumago case in Tuvalu, and the case of public prosecutor and Rooney number 2, or now popularly described as the Rooney affair. I'm not an expert on Fiji and Tuvalu, so I would like to confine my comments to the Rooney affair in Papua New Guinea. This was an incident which the Minister for Justice at the time, Mrs. Nahau Rooney, wrote directly to the then Chief Justice, Sir William Prentice, criticizing the judiciary for issuing an injunction stopping the deportation of a certain Ralph Premdas. She was subsequently found guilty of contempt of court for actions and sentenced to serve 8 months in prison. As the Prime Minister exercised executive powers to release her. Following this decision, 5 foreign judges resigned from the PNG judiciary, including the Chief Justice, Sir William Prentice, stating that the executive had interfered with the independence of the judiciary. Bernard Narakobi, writing about the Rooney affair, commented, "She was prosecuted by foreigners, defended by foreigners, and judged by foreigners according to foreign law, which Papua New Guinea had adopted under its constitution." The Rooney affair, end of quote. The Rooney affair was a difficult time in Papua New Guinea's history. Firstly, it brought to the fore one of the bastions of effective delivery of justice, the independence of the judiciary. The fact that the judiciary deliberated on the actions of a minister who was also a member of the Judicial and Legal Services Commission, the appointing body of judges, which the Chief Justice and the Deputy Chief Justice are members of, in my view, strengthened the principle of the independence of the judiciary, enshrined by Section 157 of the Papua New Guinea Constitution. The merits and demerits of Samara's intervention can be argued either way, but what it did lead to was the appointment of the first National Chief Justice, Sir Buri Kiru, and a number of national judges. The localization of the judiciary had effectively begun. This is an important point which Dr. Anna Zejik picks up in her research. One interesting conclusion reached by the study is on constitutional interpretation. There are 2 main methods of constitutional interpretation: the purposive approach and the textual approach. Dr. Zejich concludes that foreign judges are likely to adopt the textual approach to constitutional interpretation. In my view, the Papua New Guinea Constitution specifically requires a purposive approach to constitutional interpretation. In addition to this, Papua New Guinea has directive principles which are required to be considered whilst interpreting the Constitution. Being enlightened by the spirit of the Constitution as prescribed by the national goals and directive principles may or may not be due to foreignness of a judge, by the judge's personal subscription to a particular method of legal. For example, it was Justice Barnett, an Australian judge serving in Papua New Guinea, who made this statement, and I quote, "During a prolonged process of community consultation, the Constitutional Planning Committee endeavored to tap the will and spirit of the people. It then set out detailed recommendations for constitutional drafting in its report, with the intention of giving effect to the will or spirit of the people. It recommended the inclusion of the national goals and directive principles in the preamble to the Constitution. After much discussion in party briefing sessions and open debate in the Constituent Assembly, these provisions were finally enacted. Section 25 and Schedule 1.52 are both intended to ensure that this spirit, acting through the judicial mind, finds its expression in a way the detailed provisions of constitutional and other laws are interpreted and applied. This approach, the interpretation of the Constitution, was well expressed by Justice Kearney, as he then was, in the State and Independent Tribunal ex parte Sasakila, and Prentice, Deputy Chief Justice, as he then was, in Constitutional Reference Number 1 of 1977. End of quote. I also point out that Justices Kearney and Prentice were Australian judges. The study identifies benefits and challenges to engaging foreign judges in the Pacific. The benefits are that it acts as a transitional measure to localization, develops local capacity, fosters the reputation of the judiciary, and impartiality. Let me talk about impartiality. Impartiality is an important feature of judicial function. One area in which the constitutional law of Papua New Guinea allows for foreign judges to be engaged are leadership tribunals, presumably on the premise that the leader may be quite well known, such that a Papua New Guinean judge may not be able to bring an independent mind to bear on the matter, or that people's perception of bias may affect public process. Whilst tribunals are not courts, they apply constitutional laws and have judges sitting on them. Section 27 of the Organic Law on Duties and Responsibilities of Leadership provides for judges or former judges of countries with a similar legal system to Papua New Guinea to sit and hear allegations of misconduct by leaders subject to the Leadership Code. In a case dealing with the former Prime Minister of Papua New Guinea, Sir Michael Samare, who was incidentally the founding Prime Minister of the country, the Chief Justice, in impaneling the tribunal members, thought it appropriate to appoint foreign judges to hear the allegations of misconduct in office against Sir Michael. There was a judge from the United Kingdom, one from Great Britain, and another from New Zealand. This was to ensure impartiality and independence of the process. The main challenge identified by the study of engagement of foreign judges is the lack of knowledge of the local law, custom, and community values. This is an important point given the connection of the Pacific people to their culture, land, and sea. Custom is an important source of law in the Pacific. In Papua New Guinea, custom or customary law is a source of the underlying law. Most Pacific Island countries are premised on an adversarial court system. The issues that are brought before the courts, the evidence that is led, and the submissions that are made are in the main pursued by counsel, and in some sense, they limit the issues being litigated, which then drive the laws that are to be applied or developed. In the Papua New Guinea case of New Britain Palm Oil Limited and Sukuramu, the Supreme Court said, and this was in relation to the development of the underlying law, when the court proposes to apply a principle or rule of common law or formulate a rule of the underlying law, it is mandatory for the parties to bring evidence and information and make submissions for the assistance of the court. What this means is that when it comes to filling in the gaps in local knowledge for foreign judges, litigation also play a significant role. I also look at the recommendations proposed by the study The study hopes that these recommendations or good practice initiatives, as they are referred to, will aid the legitimacy and effectiveness of foreign judging. These good practices are localization, that is for local judges to sit and hear cases with foreign judges, regionalization, judges to sit in courts of other Pacific Island countries, stability, ensure greater continuity and stability in the cohort of judges sitting to hear cases, judicial independence through reducing the opportunity for political interference in the recruitment of judges, and exchange of knowledge, where greater opportunity for interchange between foreign judges and local judges to assist each other with laws in relation to issues that are peculiarly within the knowledge of. In my view, they are important and valuable recommendations on what occurs in Papua New Guinea. As the study notes, the recommendations are not prescriptive, providing a formula for a ready-made answer, but are, however, good practice to follow. Papua New Guinea does not face the difficulty where foreign judges serving in other jurisdictions face. Judges are not paid by foreign donors and international agencies on written contracts. Foreign judges and local judges are paid the same amount or have the same terms and conditions and are paid by the national government. There's also a fixed term for foreign judges, that is 3 years, and for national judges, it is 10 years. And the means to remove a judge, whether it is foreign or national, is the same. Papua New Guinea also sends judges to hear cases in Solomon Islands and Nauru under a memorandum of understanding it has with those countries. Foreign judges either work full-time in Papua New Guinea or on short-term engagement to sit in the Supreme Court through an arrangement with the Federal Court of Australia. The short-term arrangements are for Australian judges to sit on commercial matters and not on constitutional cases. What all this means for Papua New Guinea, in my view, in the country from the study of Dr. Dzejic, is that Papua New Guinea must jealously guard its present position and build on the strengths identified from this important research. My conclusion then on the work foreign judges in the Pacific is that it is a well-written and easy to understand work, although it deals at times with somewhat complicated theoretical arguments. The research is highly relevant to the Pacific and helps researchers, policymakers, and government insight into some of the workings of the judicial branch of government in this part of the world. Thank you.
Thank you very much, Judge. It's wonderful to have the perspective of a sitting judge who sits on a court with foreign judges. And there's a range of points that you made in your remarks that hopefully we'll have time to come back to. But can I just say the point that you ended up with, pointing to the particular characteristics of the use of foreign judges in PNG, the fact that they're not paid through foreign aid, for example, I think is a message for us to remember that the properties of these arrangements vary across the Pacific, even though the practice itself is shared. So thanks so much. Also for that mention of the leadership tribunal, which was extremely interesting. Okay, can we move on? Ese, will you give your thoughts on these issues, please? Thank you.
Good evening, everyone, and thank you, Cheryl. Thank you for the introduction. Also, thank you for the invitation to be part of this panel discussion. And congratulations first to Anna on the launching of this wonderful book, which shares a lot of insight into our jurisdictions from the Pacific. I am from Tuvalu. For those of you who do not know us from Tuvalu, can call me Ese. And drawing from Anna's analysis in her book of foreign judges in the Pacific, I will be speaking directly to Tuvalu's experience. Tuvalu is a small country. It's a total land area of 26 square kilometers. There's 9 islands, which are spread over a vast ocean of 1.2 million square kilometers of waters. And in Tuvalu, our court system, as of the 3rd of June this year, our judicial reform laws have just come into effect, which effectively abolished our island courts, our lands courts, and our lands appeal panel court. So now we are left with magistrates courts for all the islands, High Court, the Court of Appeal, and the Privy Council is still part of our laws. So from Anna's discussion and from the context of Tuvalu, I noted that the issue with definitions and trying to define what a foreign judge is not an easy task, although it Anna has defined it, and for the purpose I'll be using it as well, as a person who is not a citizen of a country. A judge is a foreign judge when he's not a citizen of a country that he or she sits on the courts of that jurisdiction. For my part this evening, I would like to center my discussion of 3 important points that I will be speaking to. But the question that I will be framing my discussion around is based on the book and the analysis of the Pacific in terms of foreign judges. The question is simply whether any qualified judge could be considered a foreigner in any court of law. And from that question, I will be speaking specifically to the context of Tuvalu then. In Tuvalu, there are 3 points that I want to talk to, and that the first point will be foreign judges in Tuvalu are by operation of law. And that the second point is that the court system itself is foreign to Tuvalu in any event. And that my third point would be that judges are experts in courts. So to start off with, the Constitution of Tuvalu, section 124, puts down the qualification for judges. And the section itself says that you cannot be a high court judge unless you have practiced in a jurisdiction similar to Tuvalu as a judge in those superior courts, or that you have practiced as a barrister or solicitor for at least 5 years in those jurisdictions. So by operation of our current law, we effectively rule out indigenous or Tuvaluan nationals as possible judges of our high courts. I think we do send students to study law abroad, but the qualifications that the Constitution have set are not easy for those students. Studying is one part, let alone getting a working visa in those jurisdictions is another issue to practice, and let alone being appointed as a judge to any of those superior courts in other jurisdictions. So that's the first point I wanted to raise. And the second point is that the court system in Tuvalu is foreign in any case. Everything about the court system does not properly reflect indigenous understandings of adjudication on certain challenges. Because when we are talking courts, we are talking about challenges that the legal system are looking at addressing. Our current adversarial system is more individualistic, so to speak. It's between lawyers and judges and clients and their legal issues. But our customary practices is more collective. And in that collectiveness, it makes it very difficult for the people to appreciate or embrace decisions delivered that may question the collectivity understanding of the indigenous population. And that's what Anna has discussed in the case of Tuvalu, in the Deonea case, and the Kaupule of Nanumanga. So in a nutshell, while the case from a legal perspective that was considered by the court looked at the issue and decided, they also decided that it is a matter of a constitutional right, a person's religious freedom of religion issue. Customary understanding was a bit different, and that's where the collective or the majority of where the Nanumanga people come from. They didn't see it as a religious issue or some bodies of freedom of religion right under our Bill of Rights. It was to them, in their customary understanding of the law as it stands, was that it's all a matter of duties, responsibilities, and obligations. And those matters are a matter for the collective decision of the island. And so when the court, as Anna has quoted in her book, the Court of Appeal decided it's, although there were certain customary rights and other rights that they have to deal with, it's time putting things together, that it's time, even under the principles that guide our constitution, that it's time that the Nanumanga people should be getting their freedom of religion. And that issue then, when you're speaking of that in the context of a collective society, it's very difficult for an island to understand what the court meant when the majority of the island collective right or decision making when it concerns duties, responsibilities, and obligations has been challenged by an individual, which a court has now conferred judgment favoring the individual. So the third point I want to talk about in context of Tuvalu is that judges are experts anyway in their courts. It makes it easier for us in the context of countries where we have limited number of judges to try and find judges who can sit on our courts. Because as Anna mentioned in her book, most of the feelings and the understanding that judges have, even when they are considered foreigners sitting on domestic courts, is that they represent the law and the judicial qualities of impartiality and experts. And coming from a local context of Tuvalu, that understanding makes it easier then for us to accept and deal with judges that may not be Tuvaluan. Because seen in the context of, as I have mentioned in my other point, that the court system in Tuvalu is foreign anyway to our customary context. It's not foreign to a qualified judge, because that is a judge's background. It's like playing volleyball or playing basketball. If you enjoy the game and you know the rules, it doesn't matter wherever the whole world you travel, you'll fit in nicely because it's a game you love and you know the law. And that's how we see it with judges, qualified judges, and it makes it easier for us then to embrace foreign judges working in our country. So to sum up what I have just mentioned is that the operation of foreign judges in Tuvalu is not necessarily because our laws forbid Tuvaluans, but because I think we have come so far to even fail to upgrade our laws to be relevant to our current context now, where we have lawyers and we are sending out students to be lawyers. And that's secondly, in countries where the collective nature of our customary practice is still very strong, then maybe it's something too that we can consider when considering foreign judges in our communities. And that lastly, we feel protected. I will put it in this family of legal under the rule of law, we feel protected having foreign judges in our nation, knowing that they stand and represent the law and the judicial qualities of impartiality and experts. And for that matter, we embrace foreign judges. And thank you.
Thank you so much, Ese, for that very thoughtful and thought-provoking set of comments. You know, Zoom is a wonderful medium. It's enabled us to get together tonight, and it's enabled us to bring Hugh from the other side of the world. But sometimes people make a presentation and you wish you were sitting around a table with them and had the opportunity to really exchange views. And that was one of those occasions. So thank you very much. And I'm sure there's much that you've said that people will remember and hopefully come back to in discussions. So now, speaking of someone from the other side of the world, Hugh Corder, it's over to you.
Thank you very much, Chair. We in South Africa are celebrating what we call Mandela Day today. It celebrates, it's the birthday of our founding president. And everyone is challenged to do at least 67 minutes of voluntary service during the day or at some point, and one would hope that they do not do it only on today. But this is not my 67 minutes. This is just pure pleasure. I'm delighted to be present and in such distinguished company, to meet people from important legal figures from the Pacific, about whom I read a little when I had the delight of examining the thesis on which the PhD thesis on which this book is based. But I must also initially say I'm particularly pleased to be together, so to speak, with both Ros Dixon and Cheryl Saunders, whom I have known for several decades, put it that way. I speak as a long-time observer of judicial appointments and accountability in South Africa, or Southern Africa, and my remarks will be mostly focused on this region. Let me just say, though, that I want to acknowledge and pay tribute to Anna for her PhD thesis, from which I learned an enormous amount. So I gained an enormous amount of knowledge from reading that book, but particularly also for the systematic clarity of her exposition and the raising of challenging issues which are relevant to every national jurisdiction, I would suggest. Then a contextual remark. We can't approach this subject, the subject of foreign judges serving in national jurisdictions, without recognizing the profound effects on the judicial branch of government consequent upon two things: the accelerated pace of constitution making of the past 35 years in many parts of the world, and secondly, the frequent resort to what is, I think, commonly known as democratic constitutionalism, to be seen in many parts of Central and Eastern Europe, consequent upon the fall of the wall, and in Anglophone Africa. That process was triggered, if you like, by Namibia's independence in 1990, followed by South Africa's freedom in 1994, and then one can name Kenya, Uganda, Malawi, and so on and so on. This trend has necessarily elevated the broad political profile, non-party political profile of the Superior Court judiciary, and especially the apex courts, as what Anna terms strong judicial review has become the norm. And I suggested that these developments are critical in regarding the role of foreign judges. At the same time, we must note the increasing erosion of such models latterly through the party political fightbacks, which we have seen, often grounded in populism. And we can look only, we need only refer to Hungary and Poland in Europe, as well as a number of African jurisdictions, as I will point out. Moving to the book, chapter 1 was of particular interest to me in the themes and issues set out there and the justifications and rationales for the resort to foreign judges. And I'm just going to mention 5 quickly. Firstly, the role of foreign judges in polities in transition. Secondly, the possible benefits that can accrue for the legitimacy and effectiveness of an administration of justice. Thirdly, the symbolic nature of constitutional adjudication and what that portends for the society in which it operates. Fourthly, the binding effects of precedent of an apex court in a common law-based system. And then the 4 rationales which Anna isolated in chapter 1 and to which she returned in the final chapter of the book, the particular appropriateness perhaps of having foreign judges in societies with small populations and small numbers of practicing lawyers, the potential for capacity building, the reputational enhancement that could potentially come, and the enhancement also of apparent impartiality. And then just finally, in respect of those issues outlined in chapter 1, and I was fascinated what has just been said about a judge is a judge is a judge, no matter where they are. It's like playing volleyball, and I love that image. You know the rules, you can go and play volleyball wherever you want to in the world. But one has to, and that was part of the previous 2 presentations as well, take account of the effects of legal history and tradition or national custom and national self-understanding, and those issues impact on the acceptability of foreign judge appointments, I would suggest. All of these points resonate in the Southern African region, as I hope to show. Allow me first to make a few remarks about South Africa. I was party to the constitutional discussions, as our chair has indicated, in 1993, which led to our first free constitution from 1994 onwards. And we talked about what should happen to the courts and who should be judges. Given the 160 years existence of a superior court system in the Republic of South Africa and its colonial predecessors, given the relatively sophisticated administration of justice and well-developed legal profession, which included any number of significant and hugely capable Black lawyers, all of that on the one hand, but countered by the entirely race and gender exclusive pattern of appointments to the Superior Court bench of South Africa for all but the last 2 years of that prehistory, 1991, so that there were only 2 judges of color amongst the 165 or so judges in 1993, and only 1 woman. And given the utterly unjust and unjustifiable cancer of racism which permeated much of the law, for us, the demographic transformation of the judiciary became an urgent imperative. And we naturally wondered whether Black judges from elsewhere in the Commonwealth should not be drafted in, even if for a transitional period. In the end, though, there was quite quick and uncontroversial agreement on keeping the door open to non-South African citizens to be appointed. The test for the appointment of a judge in our constitution is that the person must be appropriately qualified and a fit and proper person, although there is also an imperative that the Judicial Service Commission must take into account gender and race in the appointment of judges. So we kept the door open to non-South African citizens to be appointed as judges, except in the case of the newly established apex court, the Constitutional Court, where citizenship was and remains a further requirement. This has remained the pattern in the final Constitution, section 174. To date, no single foreign national has been appointed as a judge in South Africa. To give you an indication of the demographic transformation of the Superior Court judiciary, of the 234 judges currently in office, 109 are in South Africa classified as regarded as African, 29 as colored or mixed race, and 23 as South Africans of Asian origin, leaving only 73 judges who formerly would have been regarded as white and are still regarded as white today. So you will see that's approximately a 67% swap around. That 67% of our judges are now broadly regarded as Black. And that has, I think we've almost past the point in South Africa where a foreigner will be appointed as a judge. There's a strong and probably quite a nationalistic, if not chauvinist, legal profession, and South Africans tend to be regard themselves as rather unique, as we know, to our cost. Okay, but what about the region? 4 countries in particular have used foreign judges at least at an appellate level since independence. Botswana, Lesotho, and what was known as Swaziland till 2018, now Eswatini, and Namibia since 1990. There have been differences of approach to appointment and tenure of foreign judges, but what was remarkable before 1994 in Botswana, Lesotho, and Eswatini was the appointment, the almost exclusive appointment at an appellate level of leading advocates or barristers from South Africa whose anti-apartheid credentials meant that they'd never been offered appointment in South Africa itself, or if offered, would have turned it down. And I mentioned the names of Maisel, Sir Sidney Kentridge, George Bezos, and so on, as well as some distinguished retired judges from South Africa whose opposition to apartheid had been clear from both before their appointment as judges and even from some of their judgments. Namibia has followed a similar pattern since 1990 at appellate level, the Namibian Supreme Court level, but has also appointed foreign judges from elsewhere in the African Commonwealth, a pattern well established in Botswana, which has even appointed judges, and I say even appointed judges from the UK in the context of the very strong emphasis on post-colonialism in this region at the moment. Generally, this practice, this appointment of foreign judges has worked well, particularly in Lesotho, Eswatini, and Namibia, because the legal system doctrinally in those countries is very close to that of South Africa, whereas Botswana has a greater admixture of English law, along with Zimbabwe, Zambia, Malawi, Kenya, Uganda, as you move northwards in Commonwealth Africa. This approach of using foreign judges has endured until the last 7 years or so, which is mildly surprising given the relatively developed state of the practicing legal profession in those countries. The judges who so served did so for relatively short sessions annually and upheld the highest traditions of independence and impartiality. Their foreignness was not a great issue for most of this period, especially given their own commitment to the rule of law and basic rights and their own reputation for independence and impartiality. Latterly, however, political instability and tensions centering particularly on random and arbitrary judicial appointment practices in Botswana, Lesotho, and Eswatini, the only absolute monarchy remaining on this continent and almost in the world, have conspired to throw the judiciaries in those countries into considerable disarray and decline. And those South African practitioners and judges who were involved on their appellate courts have either declined appointment at appellate level or have resigned en bloc. Namibia remains relatively stable in this regard. In conclusion, the Southern African experience reflects many, if not most, of the experiences described in Anna's book over this period, since the mid-60s, among the Pacific jurisdictions on which she focused. While there may be exceptional circumstances in which foreign judges serve a useful function, it seems to me this practice will not be easily resorted to again in light of the developing political climate internationally, where chauvinist populism is in the ascendancy and where post-colonial sentiments abound. But the general principles identified and explained by Anna in her book remain of universal value and significance. And with that, I want to thank her and our hosts, both in Sydney and in Melbourne, for inviting me to present. Thank you very much indeed.
Thank you, Hugh. What a fascinating series of insights into both South Africa and Southern Africa. And one of the many interesting points, apart from the decline of the practice for the reasons you give at the end of your remarks, which I thought was also very arresting. But one of the other points that struck me was your point about the appointment of foreign judges from elsewhere in the region, particularly South Africa in your case. But I mean, that's a theme also that came up in Virgil's presentation, and I think is an interesting development, probably reflecting the regionalization of the world to some extent, but extremely interesting in any event. Okay, Ros, over to you for the
Thanks so much, Cheryl.
final segment.
I just want to start by acknowledging that I'm also coming from Aboriginal land and pay respect to the Bidjigal people. And I would really like to make sure to congratulate you, Anna, as the most important part of my remarks. I think this is a huge achievement as a book. And, you know, we're going to be reading and learning from it for many years to come. And of course, it would be remiss not to congratulate Cheryl and Adrian and their part in supporting what has been a PhD and now a book. I want to say a couple of things about what I think is so rich and important about the book, and then draw out what I think a couple of the implications are. But it is an absolute pleasure to be on a panel with such distinguished thinkers in this area, as well as practitioners. As Hugh said, you know, it's a long friendship and acquaintance. Essie and I met a number of years back in Sydney when she was here for an in-person workshop that you were also at, Anna, on the Tuvalu and Constitution. And Essie, it's lovely to see you again virtually. And I've learned a lot from just listening to the remarks of Justice Narakobi already, and look forward to continuing that conversation. But I'll be referring back to one of your examples, Judge, in just a minute. So one of the things that I think the field is currently grappling with is a debate that people sometimes call large N versus small n comparative constitutional studies. And do we study the whole world or do we study some countries? And one approach, which is the whole world, is usually associated with a certain kind of statistical or empirical analysis. But the best work fuses the two in a way that is focused on the particular question being asked. So a recent book by Adam Chilton and Mila Versteeg, who are some of the more sort of bullish proponents of large N approaches, try and combine large and small n in a way that answers the question they're trying to investigate about how and when constitutional rights matter. Anna, in my view, does her own version of that in a way that it's extremely valuable, which is Anna surveys the entirety of the region in a way that is a really compendious and thorough treatment. And when you turn to some of the tables in the book, you can see the numbers and the patterns really clearly in a way that reflects tremendous work, but is also a really rich resource for the field. But the real contribution of the book is beyond that in the detailed and careful case studies and qualitative work. And so I think one of the things about the book that I think is really worth celebrating and noting is that it combines large and small n in a way that's not econometric or statistical, but which is a mix of breadth and depth that I think is highly, suited to the question that's being asked, and which I think is exemplary for this kind of question, and it reflects huge work, and I think should be a model for other people trying to answer similar questions. Now, of course, you can't do the kind of work Anna's done as an individual person for the whole world, and certainly hope to complete it in less than a decade. And so again, there are always necessary limits to breadth that we have to acknowledge, and that sometimes the way we supplement that is through team-based production. But the other way we do it is through what I have called concentric constitutional comparison, meaning that we do interlocking studies that complement and speak to each other. So that the kind of work that Hugh has just really provided a brief overview of, thinking about how this phenomenon works in Africa, complements the work that Anna has done in the Pacific. But Anna already knows this because in addition to this very fine book, she has been an organizer and contributed to conferences, fora, discussions, and a forthcoming edited collection. How do these patterns globalize? What happens next when you layer in Africa and the Caribbean and other jurisdictions? So what I would say is just that I think the method is really great and exemplary for this kind of question, that the limits of it are human and necessary, limits epistemically, but that one can address that through concentric comparison, and that is exactly what your own ongoing research agenda exemplifies, Anna. The second thing that I think is really great and important about the book is that it asks a question in a broad sense about the role of foreign judges in a region, but its ultimate contribution is very granular and very nuanced. So the kind of questions that Anna asks are: who's paying? How are judges appointed? What security of tenure do they have? What's their training? How do they interact with other local judges in the profession? And the sorts of questions that you highlighted, Cheryl, in response to Justice Narakobi, which is, it matters that in PNG there's a domestic funding and sort of indigenisation of appointments in ways that have an important impact on both the reality and perception of those judges' role. And the sorts of questions that Anna is asking, I think, are really important to understanding a complex phenomenon, which clearly has advantages, but also obvious drawbacks. And so when one's asking, what is the normative valence, what is the experience of this phenomenon in all its complexity, I think it is really helpful and important to be asking the kind of fine-grained questions about institutional design that Anna asks. So where does the book take us, and what might one ask, Anna, in response? I suppose one question that's an obvious one, Anna, is at the big end of the book, you sketch some sort of these ideas, but what could we take away from this both deeply contextual and fine-grained institutional analysis about what one could call best practice around the appointment of foreign judges? Or is it too contextual? Is best practice too hard to define? I'm thinking, of course, of the Cape Town Declaration and its model of, how, commissions, should play a role. And Hugh, I think, had some, experience and role, at least, in that he could comment on. But are there any generalizations that we can draw from your work where you would be confident saying this is best practice? The second thing I wanted to ask you is about technology, which is obviously in the last couple of years, a lot of online, hearings have happened around the world, but also foreign judging has become a more remote phenomenon in many instances. And obviously the study largely preceded those developments, although you allude to them in the book, no doubt, something under time pressure to add that development. But I wondered if you could say anything from your most, recent studies and talking to people, and obviously, Justice Narakobi would also have some insight into this, about whether if you like, Zoom foreign judging has made things better, worse, or indifferent. One could imagine that it allows for lower cost and more flexible hearings and more, kind of efficiency and effective justice, but that the divide and the remoteness becomes more profound. One thing I did think, though, is I was especially interested to see that you noted the gender of foreign judges as overwhelmingly still male identifying, and wondered whether, for all the pros and cons of using more remote options, that might unlock the potential for a more gender diverse body of foreign judges. So first, best practice, second, technology. The third is still a question, and then I'll conclude with my own fourth comment, which I don't expect you to respond to, but I'd love to put out for the panel to discuss. The third is that there's a tendency, I think, in the book to emphasize the capacity building and transitional role of foreign judging in helping from an independence moment to a fully autonomous legal system. And you're very sensitive to that transition and to the aspirations for self-determination and full autonomy, and the kind of transition process that foreign judges can help facilitate. But I wonder whether there's another role for foreign judges that is more ad hoc, of the kind that Justice Narakobi alluded to in PNG, which is more or less permanent, which is in small states and small societies, the inevitability of partial, connections or personal knowledge and relationships between players, particularly between government and the judiciary in certain instances, or between very prominent individuals in civil society or the business community, may mean that one can never really fully aspire to impartial justice in certain cases, and therefore one needs the ability to bring in ad hoc foreign judges. That's happened, as you know, in the United States, in some circuits. We had it in Western Australia a few years back. We've had it in PNG in the kind of case Vanuatu had a different instance of it. But I wonder whether there will be instances where, if you like, especially in small states, and they can include sub-states within a broader, larger system, the challenge of impartiality should mean that actually the foreign ad hoc judge is the norm, not the exception, as part of a non-transitional but impartial system of justice. The best practice for that might be quite different, of course, but I wonder whether that is something which you do note very clearly in the book, but you don't emphasize as much, and which you might reflect on. So my own concluding reflection is that I think one of the challenges of talking about foreign judging and foreign judges has to do with the current moment, which has two phenomena and sort of movements which can be joined in ways that are problematic. One is a very serious and important movement to critique any form of colonial influence, to reject anything that reeks of post-colonial imposition or imperialism, and to reject everything that looks in any way like a kind of pseudo-neo-colonial influence. And of course, foreign judging is closely associated with concerns around colonialism and imperialism, depending on how it's done. And so that there's a natural tendency to criticize foreign judging for those reasons. On the other hand, we live in a moment of democratic backsliding when judicial independence is under threat in a range of countries worldwide, including in our region and internationally, in countries that for many years were seen to have relatively stable and strong systems of judicial independence, including systems like Hong Kong, where you've lived recently, Anna, and written about, and where the rule of law and judicial independence are very much up for grabs. In those conditions, it seems to me the contribution of foreign judges can be very significant. And Vicky Jackson and my work that you alluded to generously, Cheryl, talks about this a little bit, as does Anna. Not only do foreign judges bring, they bring the sort of attention of foreign governments and the media, they can bring a degree of experience around certain crises, depending on who the judges are. But perhaps most important, they can deliver fearless justice without such serious consequences to their own personal safety, in ways that are to the benefit of judicial independence and the rule of law. And so I think we are at a very delicate moment, which is that we need to be very, very conscious of the seriousness of the post-colonial critique and rejection of all institutions that have a neo-colonial association. But on the other hand, be sensitive to the fact that we are at a moment where judicial independence is under threat and where all institutions that help preserve it, including and especially foreign judges in certain countries, should be defended. And in that regard, I want to draw our colleagues' attention to the concept that David Landau and I outline in our book called Abusive Constitutional Borrowing, where my concern is that the post-colonial critique may now be the subject of abusive borrowing by those seeking to dismantle judicial independence, that they may use the rhetoric of colonialism and its critique of post-colonialism, and without any concern about its underlying commitment to equality, transformation, and self-government, and use it to defend what is effectively an attack on judicial independence and the rule of law. And that extends to the kind of South-South appointment of judges. So my view is the absolute best case for the future of foreign judging is Black South African judges helping promote and strengthen sub-Saharan judging, including in countries like Namibia, and replacing foreign judging as neo-colonialism with foreign judging as peer-to-peer, South-to-South technical assistance. But the bad version of this phenomenon is Sri Lankan judges without a training or sensibility of judicial independence and close ties to a somewhat authoritarian-leaning regime serving in Fiji in ways that look South-South, but are in very close inspection, look a lot more like an erosion of democratic independence and the rule of law. So I do think that we need to be alive to the twin moments we live in, but also to what I would call the abusive twinning of those moments in ways that lead to the promotion of South-South foreign judging in ways that, rather than being the best practice, are closer to the worst practice and a form of abusive borrowing. And I do think that that may be one reason that, as you know, Cheryl, about regions, as we work toward thinking about best practice, to avoid abusive borrowing of that kind, creating a form of South-South regional court might be some of the best hope for the future of foreign judging in a post-colonial world. But with that, I'll pause and turn back to you, Cheryl.
Right, thanks, Ros, for those provocations and for those questions to Anna. Now, I'm going to introduce Anna in just a moment, but can I just foreshadow what we're going to do for the next 20 minutes? Anna can speak for as long as she likes, but depending on how long that is, we will have some time for exchange. I'll ask the panel if they would like to put questions to each other or further observations in the light of Anna's observations. And then if we have time, and we may not, we'll have a look at the questions from the audience. Now, there is one question already in the Q&A box about panels of judges in relation to Tuvalu. I'm not entirely sure what that question means. So if the questioner wants to clarify that between now and the next 10, 15 minutes, that would be very helpful. Thank you. So now let's move to the author of this work, my friend and colleague, Anna Jedjits. Anna's presently a postdoctoral fellow in the Laureate Program in Comparative Constitutional Law at Melbourne Law School. She works in comparative constitutional law and judicial studies, but she's for a long time had a particular focus on the Pacific region. She's a convener of the Constitution Transformation Network at Melbourne Law School. In her capacity as postdoctoral fellow in the Laureate Program, she's presently co-editing the blog of the International Association of Constitutional Law, for which we encourage you all to write. And she's regional coordinator for Oceania for the Global Citizenship Observatory at EUI. As you've heard, she holds a PhD from Melbourne, an MA in Human Rights from University College London, and a BA LLB from the ANU. And Anna, it's over to you.
Wonderful. Thank you so much, Cheryl. And thank you to Virgil and Esse and Hugh and Ros for such generous comments and engagement on the book, and for sharing really fascinating insights into foreign judging in the Pacific and beyond. I've been thinking about foreign judges for many years now for my PhD and this book and other projects. And I still learn so much from talking to you all and the different perspectives and experiences that you shared today. So thank you so much. What I thought I'd do is not talk for too long so that we do have some time for discussion, but just briefly set out what I try to do in the book, and in doing so, maybe try and tie in some of the points that you raise. I'm sure I won't be able to address them all, but maybe one day we could have a longer chat. So I think in the book I try to do two things, and Ros kind of alluded to the methodological kind of approach that I take. I mean, I'm really trying to describe a phenomenon that really hadn't been fully set out before. So the book has a lot of detail about, you know, who the judges in the Pacific are, how many there are, as well as lots of information on legal regulation of foreign judges, and not just legislative provisions and constitutional provisions, but things like, well, how does a contract work between the judge and the state and a funding authority, if there is one? You know, how do immigration laws interact with the, you know, employment of foreign judges and some of those other kinds of less obvious forms of legal regulation? But then more than this detail, I kind of wanted to set out a way to understand, I guess, broadly put, the legitimacy of foreign judging in the Pacific and generally. And so I kind of tried to do this in the book by thinking about, well, what is significant about nationality or citizenship or foreignness to the position of a judge, and then use those qualities to think about how judicial office might be affected, you know, depending on whether a national or a non-national holds that position. And this became the kind of framework for analysis, a way of examining foreign judges, and it's kind of takes place across three dimensions. And I think in this might be where the most potential for generalization in terms of best practices or even just ways of thinking about foreign judging might come through. Of course, there's differences across the 9 Pacific states that I deal with, and there's even more differences across Southern Africa and the Caribbean and European states and all the other places where foreign judges are used. And I guess I was always keen to avoid an approach that kind of started from the idea, well, foreign judges are bad, or foreign judges are good, or foreign judges, you know, I wanted to be receptive to the point that Ros makes so clearly, which is that, you know, the use of foreign judges can be good. It can also be misused and open to abuse. So the three kind of dimensions of legitimacy that I come to in the book. First, that, you know, knowledge and expertise might be affected. So I think about, in particular, what knowledge might foreign judges bring to constitutional adjudication, but also what kinds of knowledge might they lack. And it's here where I think Justice Narakobi and Esse's point about, you know, how much does customary law have to be reflected in the legal system. And I think PNG and Tuvalu are quite different in this respect, because as Esse pointed out, customary law is kind of a little bit separated from the way the court works. The court is there to deal with some kinds of cases and custom deals with others. Whereas Justice Narakobi explained, in PNG, there's been a real effort to develop the underlying law to include custom as well as common law and other forms of law. So obviously the kinds of knowledge and expertise that are expected of judges, both local judges and foreign judges, will depend on what the legal system requires of them, and that might then affect legitimacy. The second point, I think, concerns independence and impartiality of judges in the judiciary. And I explore this idea that foreign judges provide impartiality by virtue of their distance from local communities. And in this, I come to the same view as Ros. I think that there is, and Justice Narakobi as well, that there is a place for foreign judges to provide impartial adjudication in certain cases. my concern when reading about foreign judging and the way sometimes the presence of foreign judges was justified in the Pacific was that this was almost inevitable, that foreign judges were needed because they would always be more impartial than local judges. And I really push back against that kind of claim and say, well, it's not the case that a local judge can never be impartial, so therefore you need foreign judges. I come down to a much more nuanced view that, you know, where a certain case requires it, access to a foreign judge can help provide impartial justice, but shouldn't be used as a generalizable rationale for the use of foreign judges. The third kind of point about legitimacy that I frame around the concept of representation, and I try and use this to understand how foreign judges can be connected to the state and the people in the Pacific country in which they serve, whilst also maintaining connections to their home jurisdictions, and increasingly this idea of a transnational community of judges as a profession that kind of has its own values, its own expectations of its members. And I was really fascinated by your comments, Esther, because they seem to confirm a hypothesis I think I float in that chapter about the role of judges in conditions of legal pluralism, that maybe people in legal pluralist societies might be more accepting of foreign judges on their courts because they see those courts as foreign in a sense. You know, they're applying a law that's been imported and a law that, you know, is quite technical. So it makes sense to also import an expert to oversee those courts. But then the concerns will arise when, say, those foreign judges try and do something that affects custom, which I think is what happened in the TNA case, that you had, you know, the court had to deal with custom in some way. And then there were concerns about the legitimacy of it doing that. So I think that while the book focuses on the Pacific, I did hope that this framework would kind of do two other things. You know, first, make a contribution to judicial studies generally by thinking through the significance of nationality. And second, to provide a way to kind of assess other instantiations of foreign judging in other jurisdictions that use foreign judges and in other kinds of courts. So I'm hoping that that's what the book has been able to do. I just wanted to end, I think, to pick up a point that both Hugh and Ros made about how is this changing, you know, that I think over time, this kind of post-colonial use of foreign judges is reducing as more judiciaries localise, as more judges kind of sit in their own states. But I think there is potential for a new kind of foreign judging to emerge in its place, where, you know, transnational connections are more likely, you know, as judges just move around, as citizenship breaks down a little bit. You have dual citizen judges, you have judges who, you know, are experts and move across jurisdictions to pursue their trade. But also as you get more, I think, internationalization of the law, of domestic law, and a turn to foreign judges potentially to address some concerns on domestic judiciaries of other kinds. So I think that the practice is changing and not necessarily going away. And I do hope that that means that this book will be at least relevant into the future as we see this practice evolve over time. So I'm sorry I haven't been able to address all comments that were made, but hopefully some will come out in the short time we have for discussion. But thank you to everybody again. Thank you.
Thanks, Anna. That was a very effective wrap-up. Now, we have just a few minutes, and so what I'm actually going to do, changing what I said before, is ask each of our panelists if they'd like to make a quick final comment of no more really than a minute or a minute and a half each, but bearing in mind two questions that have just been put in the Q&A box. One is a clarification from the previous questioner, and I'm very grateful to this person for clarifying. It's a reference to the Tuvalu case essay, and the observation is the Tuvalu case did not go down well with the Tuvalu community, which we know, would the outcome have been would have been better if the panel of judges in that case had been made up of Tuvaluans? And there's a similar sort of idea, I think, coming out of the other question in chat from Jason Varujas. And he says this: in terms of foreign judges as a foil for democratic backsliding, which is Ros's point, wouldn't an inconvenient judgment of a foreign judge be even easier for a populist executive to prey on and dismiss? Not only can the judge be criticised as unelected, but also foreign. And he points to the current and ongoing rhetoric of the British government in relation to the ECJ and the European Court of Human Rights. And I must say, as the debate was unfolding here, I wondered about that tension. You know, what is the best response to populism? Is it really to introduce outsiders? And if so, what do we think? Who should those outsiders actually be? What qualifications should they have? Or is it a longer range strategy to build up an inner strength to prevent the Boris Johnson effect? Final concluding remarks on that or anything else? Virgil, would you mind if I started with you? And is there anything final you'd like to say at the end of this very interesting panel?
Yes, I think, you know, just picking up from where the point that Ese made and which Anna also asked the you know, the point that she makes in the book that perhaps to play out of that the idea of nationalism and localization is perhaps to view judges as being representative of a profession and part of a global community of professionals where there is a need for work. They are requested to come in and perform that role. So I guess that viewing foreign judges in that way might speak to the issues of nationalism and the idea that you know, local how would a foreign judge be able to understand and appreciate local laws and custom and those sorts of issues. So I guess seeing the role of judges as a representative of a profession might be a more acceptable way of seeing judges from another nationality serving in another country. I just thought I'd say that. Thank you.
Thanks, Virgil. I don't think any of us will ever forget judges as volleyball players. Thanks to Ese. Ese, quick final remark from you.
Thanks, Cheryl. I think in response to the question that was clarified, I think the starting point that I came from was that the question of whether judges, qualified judges, could really be considered as foreigners in any court. So with that background, I think where a society is guided by laws, then it's difficult to see how a judge would go beyond or outside the perimeters of the law. So to put it in perspective, it wouldn't have mattered whether they are Tuvaluan judges or foreign judges if they, as Anna's book put, representative of the judicial qualities of impartialities and expertise in the field that they are in, then I wouldn't say that even a local judge would have gone, you know.
Fair enough. Okay.
Yes, away from the law. It will still use the law as a guiding principle for where they will end up.
Yeah.
But how they will end up there is a different. How they will reach at the conclusion, probably different reasonings, as we saw from the different judges' reasoning in the Teonea and Kaupule of Nanumanga case. Thank you.
Thanks, SM, very much. Hugh.
Yeah, very briefly, I wanted to just take up Roz's last challenging point, because that is where we are sitting in spades at the moment in South Africa, a fight back against the entire constitutional edifice from populist and, in some circumstances, almost fascist political organizations. And thank goodness they can't play the foreign judge card here. But one of the questions that is now increasingly being asked is of potential judicial appointees is their commitment to the transformative vision, which is so strong in our constitution, and which frankly doesn't depend upon what race group you come from. And there have been some shocking examples of people who are regarded as white, who are frankly more committed to some of the transformative aspects of the constitutional enterprise than some of the people appointed who are Black. Thank you.
Thanks, Hugh. Roz, final
1 minute. I just want to say, I think it matters a lot who the judges are, Tuvaluan or foreign. You know, there could be a Tuvaluan judge who struck a different balance on you know, the ICCPR and limitations, and the same with foreign judges. In doing interviews for the work I've done, and I know Anna did many more, you know, I talked to the panels in Fiji who decided the two different Karasi and Prasad cases, and they could not have been more different panels in terms of the mix of local versus foreign and their attitude and their approach to foreign judging. And so I do think it's really important when we ask these questions, it's not just foreign judges as a category. That's what Anna's book teaches us, and the same for local judges. And to your point, Jason, I think you're absolutely right. It depends on the kind of discourse that people like Justice Narakobi contribute to making non-permanent, non-local judges part of the Indigenous legal system. That's been a strength in Hong Kong. It also depends on the skill of that judge and how much they can wrap their pro-democratic judgment in domestic Indigenous laws and narratives. So I think it's a very important point, but I think that Fijian experience tells us that it doesn't always need to be so if the local community embraces and absorbs this aspect as part of their own system, and the judges who are in that role understand and appreciate that in how they approach it. And I think that the Prasad decision was a very, very fine example of that.
Thanks, Roz. Okay, I'm afraid we have to bring this very interesting seminar to a close. Anna, I hope you feel that your book has been launched. Many thanks for joining with us to do this, and congratulations on having started these important lines of constitutional inquiry, which I'm sure will continue. To the panelists, thank you so much for participating in this event and for all your insights. We appreciate it so much, and we'll be thinking about it for some time to come. And Roz, thank you also for the collaboration of the Gilbert and Tobin Centre. Many thanks also to my Melbourne Law School colleagues, Lindsay Bladen, who did so much to bring this seminar together, and Diane Holland and Angela Hendley-Boys for their administrative and technical support. And thanks very much to you, the audience. We hope you enjoyed it, and we very much hope you'll join us for later seminars as well. Thanks, everyone, and a good night or rest of the day.
Thank you.
Thank you.